So, ladies and gentlemen, dear friends of the Europa Institute, I might ask to say, dear Judge Rakoff, it is with great pleasure that I would like to welcome you here at the University of Zurich. I would say, like to welcome you back, as you have been here before. You were here at least 2 or 3 times, I forgot, 3 times, right? Once it was when Justice Ginsburg came here, and Judge Rakoff was very helpful to bring her here, to persuade her to come to Zurich, and he then gave the introduction speech to Justice Ginsburg. The other time I remember was when we met first time. There was this Bank Wegelin case in the United States. You might remember the oldest Swiss private bank had a problem before the New York courts, and they settled there, and this was in a way the end of the Bank Wegelin. And Swiss people were very shocked and unhappy about the influence of the U.S. court for a bank who had no business practice in the United States, but was purely, have a domestic presence. So why would U.S. courts have jurisdiction? But Bank Wegelin, started negotiations with the Department of Justice, and at the end of the day settled. And this settlement had to be approved by a judge, and this judge was Judge Rakoff. So basically, you decided the fate of Bank Wegelin. So when I heard about that, I thought, let's invite Judge Rakoff and talk with him about this decision. And I wrote him a letter, and he wrote me back. And he said, yes, I come. And I thought, that's wonderful, right? And we arranged everything, advertised the event, and on the day he arrived, this kind of, big Swiss newspaper, Blick, had us on its front page a big letter-headed article saying, let's arrest Judge Rakoff. He's an enemy of Switzerland. Luckily, nobody did that. And you gave the speech here, and we had a very nice meeting and discussion. And since then, we have been knowing each other. So this is a very nice event I remember very much. Now, you are one of the most prominent and most respected federal judges in the United States. You sit in a court that is situated in Manhattan, where most of the national and international big firms are located. And this is why many of those big cases at the end of the day land in your court and maybe from time to time land on your desk. Manhattan as the court of the world, as we sometimes say, positively or negatively, however you want to cite it. You were appointed by President Clinton in 1995. That means next year you are going to celebrate your 30th year as a federal judge on the bench in New York. Before that, you had studied law at Oxford and Harvard. You were a law clerk at the U.S. Court of Appeal for the Third Circuit. You then went into private practice before spending 7 years as a federal prosecutor in New York. For the last 2 years as chief of the Business and Securities Fraud Prosecution Unit. You then turned to private practice again, and you became a partner of 2 prestigious firms. I never knew why 2, but it says here, right? So you became part of 2 law firms in New York. In addition to that, you were, or you still are, an adjunct professor at Columbia Law School. You have a profound expertise in securities law, and you know both sides, right? The criminal defense side and the prosecutor side, and now you are sitting on the bench. Personally, I have to say, you are one of the quite few people that I really admire. This is because, among others, you have three things that I think in this combination are rare and very good. This is, you are very smart, you have a good sense of humor, and you are very courageous. And this combination is excellent. You are a contributor of the New York Review of Books, regular basis. You and your wonderful wife Anne are famous ballroom dancers who participate from time to time in international competitions, as I learned. And tonight you're going to talk to us about why the US Supreme Court is naturally conservative. We are very much looking forward to your presentation. The floor is yours, Judge Rakoff.
So I want to thank Andy for those very kind remarks. I'm just very grateful that my wife is not here because she would demand rebuttal time. It's a real pleasure to be back here in Zurich. I've had the privilege of being here several times, always wonderful experiences, and that's despite the fact that I don't even have a Swiss bank account. But I want to especially express my thanks to Andy and to his assistant Olivia Broy and to the Europa Institute for inviting me back. Now, the subject I'm going to talk about tonight is in some ways kind of parochial. It's about the not very positive history of the U.S. Supreme Court. And when I'm through, by the way, Andy, I'll want to have asylum here in Switzerland because they'll probably not let me back. But I thought it might be of interest to you because, as I'm sure some of you already know, the Supreme Court of the United States exercises a power that is greater than that exercised by the highest courts in many countries of the world. And I think it's not exaggerating to say that many of the major domestic disputes in the United States are ultimately resolved not by Congress, not by the executive, but by the Supreme Court. Therefore, I think it might be of interest to you to know the traditions of that court. And what I'm going to suggest is that the court, with the exception of the Warren Court years, which I'll talk about later, has been almost always a conservative court to the point, to be frank, of being quite opposed to many advances in human rights. So let's go back to the very beginning of the Supreme Court. And by the way, I should mention that the oldest federal court in the United States is my court, the U.S. District Court for the Southern District of New York. We are 9 months older than the Supreme Court of the United States. And we are really frustrated the Supreme Court doesn't recognize our seniority. But by the early years, by 1800, the United States was beginning to develop political parties. Washington had not wanted that, but it came. And the two main political parties were the Federalists, who ultimately transmogrified into the Whigs and then into the Republicans, and the Jeffersonians, who eventually became the Democrats. And the Federalists were the more conservative party. They were allied with growing business in New England. The Jeffersonians were a more viewed at the time even as radical, but they were essentially a populist, somewhat agrarian party. And it became clear in the late 1790s that the Jeffersonians were going to win at the polls. And so the Federalists did their best to stack the federal courts, where, as I'm sure you know, tenure is lifetime, with judges favorable to the Federalist point of view. And they largely succeeded so far as the Supreme Court was concerned. They did make a less successful effort on literally the last day before the Jeffersonian Congress came into being in 1801 to appoint what were called the midnight judges, a bunch of lower court judges, to the federal courts. And that led to the very famous case of Marbury versus Madison. And in that case, the great Chief Justice of the Supreme Court, John Marshall, who was Chief Justice for about 30 years, wrote an opinion which demonstrated both his desire to give the Supreme Court of the United States unusual power, and also his political shrewdness. So the issue in Marbury versus Madison was whether those last-minute appointed judges, federal judges from the outgoing Congress could still take their seats when James Madison, who was the new Secretary of State under Jefferson, had not yet signed their commissions and was refusing to sign their commissions. And the Supreme Court said first that it's up to the Supreme Court to determine what the law is. Second, that it is the prerogative of the Supreme Court to declare any law unconstitutional and therefore void. But thirdly, that in this particular case, they would rule in favor of Madison and against Marbury. And this was, on the one hand, a huge power grab by John Marshall on behalf of the Supreme Court, and the basic powers that he laid out persist to this very day. And on the other hand, he was clever enough to, in the bottom line result, come out with a result that Jefferson liked, so there wasn't a confrontation with the president. But if there was one thing that both the Federalist Supreme Court justices and the Jeffersonian justices, several of whom were then appointed in subsequent years, agreed about, it was that the Native Americans known as Indians had no rights at all. And this is vividly demonstrated in a case that came out in 1831 called Cherokee Nation versus Georgia, written by John Marshall, who was still Chief Justice. And what had happened was the Cherokee Nation, which was a sovereign nation, had agreed to a peace treaty with the United States, part of which said that certain significant lands in the state of Georgia would belong in perpetuity to the Cherokee Indians. And then in the late 1820s, gold was discovered on those lands, and the non-Indian residents of Georgia went grabbing for that land, took it over, and had the support of the president, Andrew Jackson, who was an old Indian fighter and was also, frankly, a racist. But the case came before the Supreme Court because the Cherokees said, listen, we signed a treaty as a sovereign nation, and we want that treaty enforced. And the Supreme Court, per Justice Marshall, said as follows, quote, though the Indians are acknowledged to have an unquestionable and heretofore unquestioned right to the lands they occupy, yet it may well be doubted whether those tribes which reside within the acknowledged boundaries of the United States can with strict accuracy be denominated foreign nations. They may more correctly perhaps be denominated domestic dependent nations. They occupy a territory to which we assert a title independent of their will, which must take effect in point of possession. Meanwhile, they are in a state of pupillage. Their relation to the United States resembles that of a ward to his guardian. In other words, the hell with the treaty, we're going to treat the Indians as children, and we're going to force them to move. And they had to travel by land several thousand miles to Oklahoma over a trail where many of them died and is now commonly referred to as the Trail of Tears. So much for Indian rights. So then, of course, a very big issue was the right of black people. So in the period before the Civil War, this came before the Supreme Court, most notably in the case of Dred Scott versus Stanford in 1857. And the question there was, Mr. Scott, who had been a slave, had escaped and come to a free state, Missouri, where the laws of Missouri said he was entitled to full citizenship, the same as everyone else. But his owner sued to get him back. And the case finally made it to the Supreme Court. And the Supreme Court, in effect, held that Mr. Scott was just property, and therefore had to be returned to his original owner. And they justified this through a kind of reasoning that today would be called originalism, but it was a reasoning that, well, when the Constitution was first put together, no one considered black people to be entitled to equal rights, and so we must respect that original meaning of the Constitution. So the court said, quote, it is hardly consistent with that respect to suppose that we are bound to assume anything other than that it was just and necessary to stigmatize these people and to impress upon them such deep and enduring marks of inferiority and degradation as the Constitution originally contemplated. So any of you fans of originalism think how it was used in 1857 to in effect say that black people were just property. Well, along came the Civil War, and Congress and the free states passed a bunch of amendments, the 13th Amendment outlawing slavery, the 14th Amendment guaranteeing equal rights to all citizens, and so forth. And you might have thought that that would have changed the views of the Supreme Court, but not so much. So, for example, in 1875, Congress passed a law known as the Civil Rights Act that made it unlawful for private citizens to deny an individual on the basis of race the full enjoyment of any of the accommodations, advantages, facilities, or privileges of inns and restaurants, public conveyances, theaters, and places of amusement. And that would have seemed to have been in direct keeping with the 14th Amendment. But no, said the Supreme Court, in what are called the civil rights cases of 1883, the Supreme Court said, oh no, 14th Amendment only applies to very narrowly very narrow actions on the part of the states themselves, and not to the rights of individuals or even private companies that run railroads or restaurants or whatever. And so we are declaring the Civil Rights Law of 1875 unconstitutional. And this, of course, was the start of what later came to be known as Jim Crow laws, where black people were segregated in the schools and transportation and restaurants and in numerous other ways. And just to put a further point on it, in 1896, Louisiana passed a law that said that white and black people had to not only be in different railroad cars, but actually had to be in different railroad trains. That if there was a train that was carrying white people, you couldn't have any black people on that train, and vice versa. And this went up to the Supreme Court in the case of Plessy v. Ferguson in 1896, and you would have thought that that law was a flagrant violation of the 14th Amendment. The 14th Amendment begins with the words, "No state shall make or enforce any law which shall abridge the privileges and immunities of citizens of the United States." And the 13th Amendment had said that slaves were citizens of the United States. But no, said the Supreme Court, the 14th Amendment doesn't really apply to social interactions, even if they're enforced by the state. This is a quote from Plessy v. Ferguson, quote, "The object of the 14th Amendment was undoubtedly to enforce the absolute equality of the two races before the law, but in the nature of things it could not have been intended to abolish distinctions based upon color, or to enforce social as distinguished from political equality, or commingling of the two races upon terms unsatisfactory to either." I mean, you read that and you can't be anything more than disgusted, even under the mores of that time, even under any plain reading of the 14th Amendment. This was a terrible decision, but not unrepresentative of how the Supreme Court was operating. So, Indians were to be treated as children, blacks were to be shunned and segregated. What about that other group called women? Well, the court had no hesitancy in determining that women's only proper place was in the home. So, for example, in 1874, in a case called Minor versus Happerstead, women asserted that under the 14th Amendment, they, as citizens, were entitled to the vote. And the Supreme Court said, "You got to be kidding. That's not the original meaning of the Constitution." The court, in rejecting that claim, started off its opinion by saying, quote, "Certainly if the courts can consider any question settled. This is one. For nearly 90 years, and then they went on, they say for nearly 90 years we haven't given women the vote, and we're certainly going to not start now. Of course, eventually by constitutional amendment, in the early 1900s, women gained the right to vote, but no thanks to the Supreme Court. And around that same time, with rising commercial and industrial activity in the United States, women, or really girls, usually ages 11, 12, and 13, were being put to work in garment factories and the like, with terrible conditions and with extremely low wages, but these were poor girls and they were sent out by their families to work. And in 1874, I'm sorry, wrong date, much later, in 1923, in a case called Atkins versus Children's Hospital, the District of Columbia had the nerve to say that these girls working in these factories had to receive a minimum wage. And the Supreme Court said, no way. That interferes with their freedom of contract. These girls have freely exercised their voluntary decision to work in these terrible conditions at terrible wages, and no legislature has any right to interfere with the God-given constitutional right of freedom of contract. That was 1923. So Indians are children, says the court. Blacks are originally property, and now, well, they still have to be shunned and segregated. Women don't get the right to vote, and even if they do, they can be confined to these terrible conditions. What about male white working men? Nope, they're out of luck as well. So in 1905, in a case called Lochner versus New York, New York had passed a statute saying that no one could require their workers to work more than 60 hours a week. And there was a bakery in New York where as a matter of contract, the employees were forced to work 70, sometimes 80 hours a week. And so the baker, the owner, was prosecuted by New York. He appealed to the Supreme Court, and the Supreme Court said, that New York law has got to go. It once again infringes the constitutional right of freedom of contract and will not allow this interference with this freedom to persist. And what about if the men got together and formed labor unions to try to bargain for better conditions or wages? No. Supreme Court outlawed that as well. In the case of Lowe v. Lawler, 1908, the court said that the Sherman Act, which was a progressive antitrust act passed through the efforts of Teddy Roosevelt to try to stop robber barons from being monopolists and restraining trade, they said, that most clearly applies to labor unions. And it's a crime under the Sherman Act to, in that case, boycott the goods and urge other people to boycott the goods of a company that paid terrible wages. It wasn't even a strike, it was just a boycott. it was, in the view of the Supreme Court of the United States, a criminal conspiracy. Okay. So the Indians are children. The blacks are to be shunned. The women are to be relegated to the home. The white working men better not organize on pain of going to jail. Oh yes, there was one other group that the Supreme Court thought it ought to address, which were immigrants. And this came to a head most notoriously during World War II in the case of Korematsu versus the United States. This did not even involve a law. A general in the Pentagon had issued an administrative rule that all citizens of the United States who were of Japanese descent had to leave their homes, mostly in California, and go to internment camps because there was at least the possibility, though unproven, that some of them might be more loyal to Japan than to the United States. And, consider the irony. Here we were at war with Hitler, who was putting so many people in concentration camps, and here, as part of our reaction, we took thousands of Japanese American citizens and deprived them of all constitutional rights and put them in our own internment camps. And what the court said, this was 1943, quote, exclusion of those of Japanese origin is deemed necessary because of the presence of an unascertained number of disloyal members of the group, most of whom we have no doubt are loyal to this country. So, was there any group left that could get favored treatment or even fundamental treatment under the Constitution? Oh, yes. It was those, quote, persons, close quote, known as corporations. Now, as any lawyer knows, a corporation in American law is referred to as a person, sort of as a legal fiction. I've never walked down the streets of New York and seen a corporation crossing my path. But the Supreme Court, and this, of course, was only a few years ago, in 2010, in Citizens United versus the Federal Election Commission, decreed that corporations have the full protection of the First Amendment, and therefore they can contribute corporate funds to whatever candidate they want to favor, and no election commission can stop them or restrict them or even narrow their ability to do so, because as persons, they are entitled to the full benefits of the Constitution. Now you notice that I've jumped ahead for a moment from the Warren Court. So let's talk about the Warren Court. When I was growing up, I was so thrilled by the Warren Court. It was a major reason why I became a lawyer. But looking back historically, I have to say it was something of a fluke. The Eisenhower had appointed Earl Warren to the Chief Justiceship of the United States Supreme Court because he thought he would be a conservative justice. Warren, in fact, had been a quite conservative governor of California who had approved the internment of Japanese American citizens. Another appointment by Eisenhower was William Brennan, and Eisenhower thought he could demonstrate for political reasons that he was bipartisan by appointing a Democratic judge from New Jersey, but one who had issued many opinions that were quite conservative and restrained, and so he thought, we'll get another conservative justice on the Supreme Court. Well, little did he know that Warren and Brennan would be traitors to his vision and become not only liberal, but actually do their best with the help of some leftover justices from the FDR period to bring the Supreme Court into the 20th century. And so we had those great decisions like Brown v. Board of Education, outlawing segregation in the schools, like Roe v. Wade, guaranteeing women the right of abortion, and a whole host of really decisions that in hindsight were just finally bringing the Supreme Court into accord with where the rest of society had already largely gone. But the Supreme Court, in the view of many conservatives, went too far when it decided to enforce the rights of people accused of crimes. Oh my gosh, you're going to give those folks rights? And so in a series of decisions that led to calls for Earl Warren's impeachment, the court decided Miranda and Escobedo and Gideon and a bunch of other decisions allowing rights for criminal defendants. Gideon is a good example. Gideon held, breaking with all prior precedents of the Supreme Court, that someone who was indigent and was accused of a crime had a right to a lawyer. Oh my gosh, you're going to give lawyers to those crooks? It was met by many parts of the United States as a radical break with the traditions of the law and of the Supreme Court. But it didn't last all that long. President Nixon was elected in 1968, partly on a pledge to get the Supreme Court back to its conservative roots. Ronald Reagan ditto. And long before the present Supreme Court, which is viewed as extremely conservative, the justices of the Supreme Court began eroding many of the decisions of the Warren Court, especially in the area of criminal rights. So, for example, in the case of Los Angeles versus Lyons, 1983 case, Supreme Court held that it was perfectly proper for police to use chokeholds in arresting someone, even if there was no resistance, because that was not something that past precedent had outlawed. And the result, as I'm sure many of you know, were people who were killed by chokeholds in places like Detroit and Los Angeles. The Warren Court was something of a break, but a very temporary break with the unfortunate traditions of the Supreme Court that I've outlined. So you might ask, what accounts for the fact that the Supreme Court has always been so regressive, especially when it comes to human rights? And I think there are two answers. One answer is that the conservatives have been much more centered on the Supreme Court as where they want to place the people they want to have power. Because as the electorate over the course of American history has moved in positive directions and accorded much greater rights to blacks and Indians and so forth, women, homosexuals, the conservatives have felt, well, the one place we can put a stop to this, or at least slow it down, is in the unelected branch of our government, the Supreme Court, and we will do a lot to place our folks there. And that's most obvious in the 3 recent appointments by President Trump, but it really has a long, long history going back to the Federalists. But the second reason, and one less obvious, is the Anglo-American legal system's concern with precedent. To a remarkable extent, the Anglo-American system of law is backward-looking. When I and any other judge gets a new case, the first thing we look to is, has this issue or something close to this issue been decided? And if so, that's it. That's the end of the question. Now, the origins of that respect for precedent go back to Anglo-Saxon times, when it made a lot more sense. In those days, there were no laws. The parliament did not exist, and it was really judges who decided what the law was. And so you had the problem if one judge decides this and another judge decides that, how are you going to provide the certainty and reasonable degree of predictability that any system of law has to have? And so there developed the notion of great respect for past precedent. Even if you don't agree with it, if some judge had decided it in a very similar case previously, you were bound to follow that precedent. Now that, I would suggest, makes a lot less sense in the modern world where statutes and administrative regulations are so much the centerpiece of the rule of law. And in fact, in most European countries, and indeed in most countries of the world that are not former British colonies, the approach is to look to the statute first. This is the Napoleonic Code and its evolution since then. And if the statute or the rule, administrative rule, was just passed yesterday, great. We have an answer to this particular dispute that we're dealing with. We don't have to worry about what some court decided 100 years earlier. Switzerland, as I understand it, has a particularly interesting gloss on this. And I hope I'm getting this right, but my understanding is that if a judge in Switzerland is confronted with a dispute that he cannot resolve by looking at the statutes or regulations, he then is told, imagine you are a current legislator, and how would the legislature now deal with this today? Totally opposite to the way judges in the Anglo-American tradition look at situations like that. A good example of what I'm talking about is the Supreme Court's fairly recent decision in Dobbs holding that there is no constitutional right to abortion. Now you may think, well, gee, there was a precedent, Roe v. Wade. So how come they didn't follow that precedent? Well, if you read the opinion, what it says is that for 100 years, the universal precedence of the United States was that there was no right to an abortion, that it was left to the states to determine. And Roe v. Wade was one of those crazy decisions from the Warren Court types that just disregarded precedent. So we feel quite comfortable overruling Roe v. Wade because it really was not in accordance with the way we look at the law, which is to go back to the real precedents. And so you have the current situation. Now, I don't want to end on a totally grim note, although I do think that this tendency of the Supreme Court of the United States to be repressive and regressive is going to continue for many years to come. But the good news, if there is good news, is that society moves forward and its elected representatives in the form of the president and the Congress move forward. And eventually, even the Supreme Court feels it can no longer counteract those trends. So even with the great power that it has had since Marbury v. Madison, it exceeds to the developments in the rest of the country. But it does so very slowly, sort of looking backward with regret as it does so. One example of this is the Korematsu's decision in turning the Japanese Americans. It's never actually been overruled. The Chief Justice Roberts, in a recent decision, said, well, everyone agrees Korematsu was a terrible decision. It was nice of him to say that, but it is, in fact, still the law of the land. So I hope I have not bored you or discomforted you with these remarks, but I think as outsiders looking into how the American government operates, you should be aware that a major force for regressiveness has historically been the Supreme Court of the United States. Thank you very much.
Thank you very much, Judge Rakoff, for this presentation. You took us through the history and the most important, also mostly negatively viewed decision by the U.S. Supreme Court. And you came to the conclusion that the conservative tendency of the Supreme Court lays maybe also in the common law legal tradition that refers backwards and not so much refers into the future. Now, I would like to start maybe the Q&A session, and I would like to invite all of you to participate and ask questions. I would like to start with the first question, maybe. You refer to this battle between originalists and those who advocate for a living constitution, represented by maybe Justice Scalia and Justice Ginsburg, who both were here, as you remember. And you leaned to me, more towards the living constitution camp. Now, where would you draw the line for a judge? How much reinterpretation of the Constitution is possible? Where would you say now a court or a judge oversteps, his or her power, and what is decided here should be left to the, to Congress, to constitutional amendments or so? Where is there the borderline?
So the reality is the borderline is in the eyes of the Supreme Court of the United States. But I'll give you an example from my own personal work. So I was personally originally in favor of the death penalty. In that, to be brutally frank, was because my older brother was murdered in cold blood when he was 43 years old. And if you would ask me then, I would say the killer who was caught doesn't deserve to live. He's forfeited his right to live. But my mind was changed by new developments, and the most important of which was the advent of DNA testing. And through DNA testing, the courts of the United States were increasingly confronted with examples of people who had been convicted of murder, placed on the death row, and yet were actually innocent. They weren't the murderers at all. A mistake had been made. And this was, frankly, mind-boggling to me. And as the numbers increased from a few to 100 to most recent number I've seen is 400, I began to rethink the situation. And it seemed to me that since the Supreme Court, in a case called Herrera, had said that it's never too late to assert actual innocence, if new evidence develops that shows that you're actually innocent of the crime of which you've been convicted, even if you've been previously convicted, you can still bring what's called a habeas petition and reassert your right to be free. And based on that, it seemed to me that if you execute the guy before he's had a chance to have DNA testing, you are potentially executing an innocent person. So on that basis, back in 2002, I declared the death penalty unconstitutional. And for me, it was a very major change in my own thinking brought about by new developments. Well, I wasn't too surprised when I got reversed in like 5 nanoseconds. The Court of Appeals said that, well, Herrera didn't, even though I quoted it correctly, didn't really mean that, and that the Supreme Court had already decided, after the Warren Court had held the death penalty unconstitutional, the Supreme Court had almost immediately reversed that, and that was the binding precedent, and the rest was decided, and these new developments were irrelevant. And so I was reversed, and the death penalty still exists in the United States, and people are executed every year. And I give you that as an example of how devoted to past precedent the courts of the United States are. My opinion was based totally on new developments, but new developments that were not in question. The DNA exonerations had been approved by courts, had, in the great majority of cases, been accepted by the prosecution. But as far as the higher courts were concerned, they weren't, that was not a sufficient reason to tamper with their interpretation of past precedent.
So could Congress pass a law that declares the death penalty unconstitutional or illegal, or would the Supreme Court strike that down?
No, I think Congress probably could pass such a law. What Congress could not pass, and has been totally unsuccessful in passing, are laws for gun control. And so we have this terrible situation in the United States where there are routinely killings by people who so easily obtain guns. And every time Congress or just the states have tried to put restrictions on that, the Supreme Court has said, oh, no. The original meaning of the Second Amendment was that everyone had more or less unfettered right to a gun, and we're going to uphold that. And that, of course, was mostly the doing of Justice Scalia. So I think Congress cannot pass such laws today. And I don't want to be too negative. I am very proud to be an American. I think my country has many, many, many strengths. My own ancestors would probably have all been murdered in death camps if the United States had not allowed them to come here. But we do have serious problems, and the point I'm trying to make is some of those problems are the fault of the courts.
Thank you very much. Now, who has a question or comment to Judge Rakoff, please?
Thank you. It was a very interesting presentation, if I may say so. I feel that you're voicing frustration with the lack of the legislative process in the United States, but my question is not that. In these early cases with the Indians and the blacks and the slaves, the court was split, I suppose, or was it unanimous, or how did the voting go?
The court was unanimous in the Cherokee case, and indeed, only in the last 3 years has the Supreme Court even recognized the fact that maybe the United States does have to honor its treaties with the Indians, most of which go back 100 or 200 years. The more common approach has been that in the Cherokee case, which was a unanimous opinion. I don't remember whether Dred Scott was unanimous or not. I think it was, but I'm not 100% sure. Korematsu, the case involving the Japanese Americans, there were 3 dissenters, but it was interesting that many of the justices appointed by Franklin Roosevelt, who proclaimed themselves to be liberal in some sense, all voted for that decision, saying, in effect, we're at war, we can't take the chance there might be a disloyal Japanese American here or there, although not yet determined. Too bad, move them off to internment camps. In terms of Plessy v. Ferguson, the upholding of segregation, my recollection is that was 8-1. I think Justice Harlan was the only dissenter in that case. So these have mostly been substantial majority decisions.
You mentioned Marbury versus Madison, and where the Supreme Court, in a way, made itself or put itself, you could say, above the 2 other branches of government, because the Supreme Court can now control all actions of the president or of Congress on their constitutionality, but nobody, in a way, can control decisions by the Supreme Court, right? Do you think the U.S. Supreme Court is too powerful? I mean, this power is not really, mentioned, at least that way, in the Constitution. Should Madison, the decision Madison, be reversed?
Well, that question was fought out in part during the Civil War when, of course, the southern states, even though they had won in Dred Scott, were not happy with the notion that they could not nullify opinions of the Supreme Court. I think the issue in any of these circumstances has to be, what's the alternative? If the Supreme Court is not the last word on what the law is, who should be? Should it be the Congress? Should it be the executive? I think there are greater dangers maybe there than exists when it's the Supreme Court. So my quarrel is not so much with the holding in Marbury versus Madison, although it was a power grab at the time, but in the way that the Anglo-American backward-looking reliance on precedent has made it an instrument for repressiveness rather than for progress.
So I hand up there.
Thank you for coming and for sharing your thoughts. So my question actually is not about power, but legitimacy. So, I mean, for a long time, the Supreme Court was highly revered, respected, considered to be beyond legitimacy, and we've seen the last 25 years that the approval rating has gone from 70% down to 40%. And is that something that concerns you? And if so, what could be done to improve it? And then, I don't want to prejudice your answer, but I've been looking around and doing some work around this, and when you look at what the the Supreme Courts that enjoy the highest degree of legitimacy, including the Swiss, you see certain attributes. So, one is this aspect of, legal overreach where, in the case of the U.S., there seems to be some criticism, as Andy points out, that a lot of things are being decided that probably should be in the domain of democracy. I mean, these are sort of things that Lord Sumptuous have talked about. And then the other points that sort of come about is one, the number of Supreme Court justices. I mean, you only have 9. 25% of the cases are decided by 5 or 4, including 2 of the most important. The Citizens United case and also the gun control case were both 5 to 4 votes. So those sort of votes are not particularly convincing to the public. So could perhaps the number of justices be increased as a way of increasing legitimacy? And yeah.
I'll address your second question first. I don't think it's a good idea to increase the number of justices, because pretty soon, every time a new administration comes along and they're not happy with how the Supreme Court is ruling, they'll increase the size of the Supreme Court so they can appoint a majority. So I think it's a slippery slope that will ultimately come back to not be a good idea. In terms of how people view the Supreme Court, the Supreme Court is supposed to be independent. It's not supposed to be seeking popularity. That doesn't mean that it hasn't had to pay some attention. That's why, even with its backward-looking views, it's occasionally moved forward. But I don't think it's a question of any particular time. The Warren Court, which, in my view, did more than any other court in the history of the United States to bring the courts into the modern world, was extremely unpopular. You could not go down a highway without seeing a billboard, "Impeach Earl Warren." So I don't think a popularity contest is really something the courts have to pay too much attention to. A little bit maybe, but not too much. So that's my answer to your questions.
First, black there, please.
Thank you. Forgive me because I'm not a law student and not a lawyer, but I'm going to try to
Don't brag.
Okay. I was wondering if you could talk about the recent decision the Supreme Court made about the Colorado case, if they could prevent certain people from being on their election ballots. If you could talk about that in the light of this conservative tendency, and along that line, I mean, I really don't understand what they did because it didn't seem conservative to me. And Judge Lutig, who you might have seen, he's famously conservative, felt that it was a wrong rationale or decision.
Well, a lot of this traces back to the question of whether a state can be the determiner of federal law. The Colorado decision was unanimous, and I wasn't frankly surprised because Colorado had no business deciding what federal law required or didn't require in this particular case. So I think that was the fundamental problem there, forgetting about the merits. Just the Colorado court was out of its proper jurisdiction in making the determination it did. So I don't, there's a broader question that's lurking there, which is the one of states' rights versus federal rights. This is one I'm sure people in Switzerland should be sensitive to because you have a federal system too, although as I understand it more and more, it's centered in the federal government. But in the United States, of course, we have a federal system. And just to take one example, criminal law is still 90% in the states. We have a huge problem in the United States of so-called mass incarceration. We lock up in the United States 2 million people every year. That is hugely more, both in absolute terms and percentage terms, than any other country in the world. And that's mostly done in the states. And the Warren Court was the one and only Supreme Court that tried to address that and impose federal limitations on that. But that's been largely undercut by subsequent Supreme Court decisions. And so it's the states that are mostly dictating the criminal laws of the United States, and that's led to some very bad results.
Thank you, Justice. Very interesting. I'm sorry, I'm a lawyer, so my question will be legal.
My condolences.
The United States is known for its very powerful law enforcement system. Even this beautiful instrument as a tool, extraterritorial principle are working very efficient. But what's wrong with international law enforcement when it's come to massacre, when it's come to war crimes, when it's come to terrorism, so when it's come to obvious cases? Thank you.
Well, I don't claim to be an expert on international law. I did serve twice in helping to train prosecutors in the International Criminal Court in The Hague. And to be perfectly frank, I was not overly impressed with that court. The judges of that court are appointed by all the signatory countries. The United States is not a signatory, but most countries are, many countries are. And it's something of a, what we call in the United States, a boondoggle. So you'll have a judge who's not doing very much and doesn't know much about international law or anything from some country who'll be appointed, wow, 3 years in The Hague, I can't beat that. Now, there's some good judges too. Another problem with that court is they can't make up their mind as to what kind of procedures they should follow. And so it's a function of, there's a British judge who's presiding, they follow the British approach. If it's a French judge, they follow the French approach, and so forth. So I have not been overwhelmed by that court, but I don't claim to have a broader, detailed knowledge of international law.
I see there is a hand up very much in the back.
Thank you for your insights. And is there a need for the Supreme Court to have better rules of conflict of interest, better enforcement of the code of ethics, especially with Clarence Thomas? Because out of my perspective, there seems to be like no accountability for the Supreme Court judges.
Yeah, so this is something that is very close to my heart, because all the lower court federal judges like me are governed by strict ethical codes and rules. We have a detailed code of ethics that we need to follow. And if we have any question about how we should act in a given case, there is a committee of judges who we go to who give us binding decisions. Here's what you can do and here's what you can't do. So, for example, when I came here to Switzerland, it never occurred to me that I could come in a private plane like some unnamed Supreme Court judge, because that would have been a clear violation of the rules that govern the rest of us. The Supreme Court has never had a binding ethical code. In fact, until a few months ago, it had no ethical code. And there are some extraordinarily terrible cases of conflicts of interest by Supreme Court justices that occurred in the past. I will give you just one example. During World War II, there were two Nazi submarines that landed in the United States, one in New York, one in North Carolina. And they were caught almost immediately because one of the 8 crew members went to the FBI and said, I'm not really favorable to this saboteur group, and here's how to catch them. So President Roosevelt then said, okay, we'll appoint a military court that will decree the death penalty for them. And there was a little problem. His attorney general, a fellow named Biddle, said, there's a decision of the Supreme Court that says, that grows out of the Civil War, that says, even if someone is a terrorist or a saboteur or whatever, if they commit a crime on U.S. territory, they have to be tried by the established U.S. courts, not by a special court created for that purpose. So FDR said, oh, that's no good. So I'll call up my favorite sitting Supreme Court Justice, Felix Frankfurter, and I'll ask him how to design this legislation so we don't have this problem. So he called up Frankfurter, and Frankfurter, without missing a beat, said, oh, well, you have to have this clause, and you have to eliminate that clause, and so forth. And then the military tribunal was set up, and the next thing that happened was that defense lawyers made an application to the Supreme Court saying, this is contrary to that earlier decision called In re Milliken, and so this court has no jurisdiction to try us. We should be tried in a regular U.S. court. So FDR was a little worried about that, so he called up another of his favorite justices. He had appointed 7 of the 9 justices by that time, and he called up Hugo Black, and he said, just tell the other 8 justices that if they rule in favor of these Nazis, I'm not going to enforce their decision, and I mean that. So Black then convened on a Friday before the case was going to be heard, a meeting of all 9 Supreme Court justices, and reported what Roosevelt had said. And then on Monday, the 9 justices unanimously denied the application of the lawyer representing the Nazis in a 1-sentence decision that gave no reasons why they were able to disregard the Milliken decision. The military commission then promptly convicted them 2 weeks later, and 6 of the 8 were then executed. Now, they were bad people, but that does not excuse, in my mind, for 1 second, the gross conflict of interest that what that case represented, where instead of being independent of the executive, they were just being told by the executive what to do. About 2 months ago, maybe 3 now, under very intense public outcry, the Supreme Court purportedly adopted a code of ethics, but it's largely a sham, and I don't say that lightly. And I'll give you an example. The code of ethics that binds the lower court judges say that if you have a clear conflict of interest, for example, if you own stock in one of the parties to a case, you must recuse yourself. You must eliminate yourself from the case. The code adopted by the Supreme Court says, if you have a clear conflict of interest, number one, you're not required to recuse yourself. That's an individual decision. And number two, we discourage you from recusing yourself because we want all 9 justices to participate in the decision, if at all possible. Think about what that means in a 5-4 decision. The decision may be decided by the vote of a guy who is clearly conflicted. And that's the great new ethical code of the Supreme Court. So I think we've got a long way to solve that problem.
There is a hand, please. I didn't see that. Sorry for that.
Thank you. Thank you very much for this opportunity to ask a question. And Your Honor, thank you for interesting lecture. And actually, I have several questions, but before that, let me please a bit give me my background, because I'm from Ukraine and I previously worked in Ukrainian Supreme Court. And although in Ukraine we also don't have such a power of precedent as in US Supreme Court, however, every lower courts and of course the Supreme Court itself have to follow the legal position. However, it happens so when the court has to change its legal position. And of course, there is a big discussion then in a society, because there was a course of cases like that were decided in one direction, and then when this legal position changes, the court practice goes in another direction. So how is it with the US Supreme Court? What are the factors that can make it change its legal position, for example, as it was in the case on the abortion? And how these influence further court practice? And in this case, for example, in abortion, was it because only that the conservatives had the majority there, or there were also other factors that influence its changing of the legal position? And in case there will be liberal majority, will it, or how much will it influence the further court practice? Thank you very much.
Quite the list, right?
Yeah, I wish someone would give me a yes or no question. As I said, my view is that normally the Supreme Court, like most lower court justices, their first instinct is to look to past precedent. In the case of abortion, they had the problem of Roe v. Wade. But they were able to say that Roe v. Wade had departed from that adherence to precedent and therefore was illegitimate. So the position that the majority took there was it has always, according to our past precedents, been up to the states to decide whether abortion is legal or illegal. Along comes this decision of the Warren Court in Roe v. Wade that says there's a constitutional right to abortion. That was not based on past precedent. That was contrary to past precedent, and therefore we feel totally comfortable in overruling it because it didn't play by the rules. That's sort of what the majority said there. As you will not be surprised to learn, I think it was the Dobbs decision was a terrible decision. But my point to your question really was the justices in the majority felt that they were playing by the rules that I've tried to argue are so backward-looking that they're not very good in a modern society.
Dear Judge Rakoff, I think we have to come to an end of this session here tonight. Thank you so much for coming here all the way from New York, for delivering this speech to give us insight on important decisions by the court, and also trying to have some optimism somewhere at the end. I'm not sure how convincing you were there, but we are very grateful for that, of course. We have a little gift for you, which should not put you in any conflict of interest. because
so
it's...
there are rules about that, which is that everyone but the Supreme Court can take gifts of any amount. But us lower court judges can take a gift if it does not exceed value of $75. So I'm hoping this is worth $74.99.
Yeah, I think so. I think so. It depends on you how you value Swiss chocolate, right? I mean, of course, it is priceless.
Yes, priceless.
So there is Swiss chocolate there, and there is also a little, kind of whatever vase made in Zurich. This is especially, of course, for
I may
your
have to break the vase, but I'll eat the chocolate.
for your wife, and so she might not be falling under that rule, right? If the gift is for your wife, and the third thing is something we just discussed, and you discussed it today. It's a little picture of Article 1 of the Swiss Civil Code, right? That you just said, application of the law. The law applies according to its wording or interpretation to all legal questions for which it contains a provision. In the absence of a provision, the court shall decide in accordance with customary law, and in the absence of customary law, in accordance with the rule that it would make as a legislator. That's for you on your desk back home. Thank you very much for coming to Switzerland.
Thank you.